Good afternoon and welcome to this, our 6th webinar in the Switalskis MCA webinar series. Thank you for attending and I hope you will enjoy it. Thank you for the time given by all the speakers in the series and the gift of their experience and expertise. All the webinars will be on the Switalskis website in due course. I'm happy for you to ask any questions at the end. Can you put them to the Q&A facility rather than the chat facility? It's much more easy for us to manage that. So our next speaker is Brett Davies. Brett heads up the Adult Social Care Department at Wakefield City Council. He deals with complex court of protection matters and regularly advises in social care matters under the Care Act 2014. Today, he's going to talk about local authority safeguarding procedures. Over to you, Brett. Thank you.
Thank you, Alison. While I work out how to share the screen. Get the slides up. There we are. Thank you, everybody. It's a pleasure to be invited to come along and speak to everybody about safeguarding for local authority adult social care departments. I intend to spend some time just covering the basics of adult safeguarding, or the fundamentals, what you really need to know. With a focus on capacity and the Mental Capacity Act as we go along. And then about halfway through the time we've got, I've got some particular issues that I've come across in the past couple of years, which from a capacity point of view are interesting and they challenge my practice. And so I think they'll be of use to everybody. So starting at the very beginning, with what is safeguarding, what do we mean by that? And this is an extract from the Care and Support Statutory Guidance. And obviously, safeguarding means protecting an adult's right to live in safety, free from abuse and neglect, so keeping them safe. But it goes on to say that at the same time, safeguarding is about making sure that the adult's well-being is promoted, including where appropriate having regard to their views, wishes, feelings and beliefs, and deciding what action, if any, must be taken. And when we look at safeguarding from a capacity point of view, that's really important. Within the Care Act statutory guidance, we have 6 key principles of adult safeguarding. They are set out on the slides. Empowerment, again, when we look at safeguarding in the context of capacity, really important that people are supported and encouraged to make their own decisions and give informed consent to actions that are taken by them or for them. We've got prevention, better to take actions before somebody's actually harmed, and we'll look at that particularly through the prism of interim safeguarding plans a little later. We've got proportionality, proportionate to all kinds of things, so proportionate to the risks which the adult faces, proportionate to the interference which safeguarding actions might have in the private life of the person we're trying to protect, but also their wider family as well. Proportionality in terms of the response. Is it a proportionate response to what's happened? So that's something we'll look at as well in more detail. We also have protection as a key principle, protecting those who are most vulnerable and have the greatest need in the community. We have partnership, and I've got an example where we look at that just in passing through the context of coronavirus and safeguarding in terms of whether or not a service user should have the COVID-19 vaccine. And we've got accountability or transparency, so making sure that the decisions social work practitioners and other professionals take are transparent and defensible. So going back to the Care Act statutory guidance, and again with a particular emphasis on capacity, the real core, the real thread of safeguarding practice is making it personal. If safeguarding were a stick of rock and you cut it in half and expect it to say making personal through the rock. So this extract is useful to emphasize that point. It talks about 4 lines down, having different preferences, people having different preferences, histories, circumstances and lifestyles. And so having a prescribed process that must be followed whenever a concern is raised isn't going to work. It carries on that safeguarding should be person-led and outcome-focused. So person-led, so really listening to the person that we're trying to protect and bringing them along on the decisions and actions that are taken. And outcome-focused, from the very beginning, thinking about what the actions taken, particularly in the initial stages of a safeguarding inquiry, are and what they might do to potential outcomes for the person we're trying to protect. Engaging the person in a conversation about how best to respond to their safeguarding situation in a way that enhances their involvement, their choice and their control, as well as improving quality of life, well-being and safety. So they're really important. That's the really important backdrop to safeguarding. Before we move now to look at the legislation. The key piece of legislation is obviously Section 42 of the Care Act 2014, the inquiry by a local authority. And it's set out on the slide, and the bits in bold I'm just going to touch on because they're really important. And the first is the threshold for involvement by the adult safeguarding team here is very low. It's reasonable cause to suspect. So when we look at the 3 criteria that have to be met, they don't need to be met on the outside. We don't need to be satisfied that that is the case. We just need to have reasonable cause that it might be the case. And the 3 criteria are somebody who has needs for care and support. Secondly, whether they're experiencing or at risk of abuse or neglect. And thirdly, as a result of those needs, so causative nexus, they're unable to protect themselves. And if all 3 of those criteria are met, then the duty is triggered and the local authority has to, so it says local authority must make or cause to be make whatever inquiries it thinks necessary in order to decide what should be done to protect the adult or safeguard the adult, and if so, by whom. So who does it really apply to? Well, the first criteria is it's somebody who has needs for care and support. So at this stage, we're only concerned with reasonable cause to suspect. But what we're looking for is an adult who has care and support needs that are related to a physical or mental impairment or illness, and not just caused by circumstantial factors. And the needs that arise from the physical or mental impairment have to lead to the adult being unable to do what are termed as the eligible outcomes. So it needs to have an impact on their ability, for example, and there's quite a few of these, but for example, to manage and maintain their nutrition, to maintain a habitable home, or to carry out caring responsibilities in relation to a child. That's what we're looking for. And thirdly, because the adult isn't able to achieve those things, there'd have to be a likely significant impact on their lifestyle. Now that's really important because what that does is link the safeguarding inquiry to the provision of adult social care and support. And it takes out of the equation, for example, a domestic violence incident between 2 people that live at home that don't have needs for care and support. Those matters are dealt with by other organisations such as the police. So when a referral is received by a local authority, in respect of safeguarding, it will be triaged by the local authority to make sure that this is an appropriate referral and relates to a service user who has, or there's reasonable cause to suspect has, care and support needs. The second is they need to be experiencing or at risk of abuse or neglect. And in the subsequent slides, I've set out what we mean by abuse or neglect, and we're just going to skim over those and you'll be able to read that at your own leisure. And the third one's really important, which is that because of the care and support needs, the adult is unable to protect themselves. So again, it all links back to care and support needs. And an example of where that causative nexus might not be there is in a case of financial abuse in respect of an adult that perhaps only has physical care and support needs. Perhaps they've had a stroke or they have some other physical impairment, but emotionally and mentally no difficulties, and they're making decisions to transfer money to family members, perhaps even because family members are exerting undue influence or coercion upon them or threatening them. But if the adult is transferring the money and it's completely unrelated to the physical needs, and it's outside of the Care Act, and it's a matter that should be dealt with by other agencies such as the police. So it applies to everybody, the safeguarding duty, regardless of whether they have capacity. It applies in all settings, except for prisons and approved premises, so approved premises with the probation service, where somebody might move to on release from prison before moving to reside in the community. It's a very broad duty, which we'll come to see. So very briefly, what do we mean by abuse? This is here for reference really, but we've got physical abuse, obviously hitting people. Also includes misuse of medication, restraint, which would include deprivation of somebody's liberty, domestic violence, sexual abuse on there, psychological abuse, so emotional harm, controlling coercive behaviour, being exposed to others in a household being violent or aggressive to each other. Financial abuse, which is probably the most prevalent safeguarding concern that I see. Generally, people taking for their own other people's money when they are a trusted family member, or abusing positions of trust, like a lasting power of attorney. Other forms of abuse just listed there: modern slavery, which is actually much wider than you might think, discriminatory abuse and organisational abuse. Neglect, obviously an acts of omission. The most frequent cases of neglect that I see involve people who don't engage with carers. They need prompts to take their medication. They don't eat or prepare meals for themselves or clean the home for whatever reason. And also we're seeing quite a number of hoarding cases at the moment as well, which falls within the neglect, self-neglect category. So what is the duty upon the local authority? Well, it's a duty to take action and cause inquiries to be made, either by itself or by having other agencies do it. And in a very straightforward, simple case, that could merely be a conversation with the adult, where after some discussion, the adult considers themselves safe, they don't want to take any further action, they know we're here if they need any help in the future, and that's fine, it closes down. Through to very formal safeguarding inquiries where experts are involved, multidisciplinary professional approach, and extensive findings are required by the safeguarding social worker. But whatever the inquiry, the focus should always be, and again with a focus on capacity, should be on improving the adult's well-being. Because it's a duty to make inquiries or request others to make them, often, and in the majority of cases, the inquiries are undertaken by people other than the social workers employed by the local authority. Very often, if the safeguarding referral relates to a registered residential setting, then it will be the care provider who intakes the inquiry, even if the allegation is that it's a member of staff that has allegedly caused harm to the service user. And that's because there'll be a registered manager. To some degree, it's independent. There's a framework provided by the Care Quality Commission, the CQC. There's usually a contractual arrangement between the provider and the local authority, if it's a provider that's commissioned by a local authority. And that's the most proportionate way of resolving matters. Obviously, if the referral is one in a string of referrals alleging abuse in that residential setting, then the local authority will have to do something about that. But that's an example of another agency. Often, the local authority's duty is to request other public authorities who have a duty to cooperate with it under Section 6 and 7 of the Care Act to carry out inquiries for it. So the example that I've given is it might be the GP or the Clinical Commissioning Group, the CCG, who are requested by a local authority to take action. And the example is, I'll put on the slide, the coronavirus vaccinations. It might be that there's doubts about a service user's capacity to consent to the coronavirus vaccine, and family members are obstructing that. Perhaps they have lasting power of attorney and they object to the vaccine being given. Well, in those circumstances, the first thing that needs to happen is likely to be the capacity assessment itself. And there are really good reasons why a local authority social worker isn't placed to undertake that capacity assessment. Most obviously, the local authority is not the decision maker about whether or not the vaccine should be provided to the service user. But secondly, a local authority social worker will not have expertise or experience in the relevant information that's likely to form the basis of a capacity assessment around taking the coronavirus vaccine or having the coronavirus vaccine. After all, the relevant information will include that the vaccine is a medication, that there may be some side effects, but the social worker wouldn't know what the side effects were. There might be complications with the service user's own health history. They may have allergens and those sorts of things, which the GP is better placed to be able to formulate as part of the relevant information. So that's a very good example about where, if a safeguarding inquiry arose through the prism of whether or not a service user should have the coronavirus vaccine, that's the reasons why that should be passed over to health to undertake. So what's the objective of a safeguarding inquiry? Well, making it personal, as we know from the backdrop to the legislation. A key objective is to ascertain the adult's wishes and feelings, and they're incredibly important whether or not the service user or the adult in question has capacity. The second thing to do is to assess the needs of the adult for protection, support and redress and how they might be met immediately. So we'll come on to look at interim safeguarding plans, but does something need to happen immediately to keep that adult safe and well whilst we gather evidence and properly plan over the next weeks or so? So protect from the abuse and neglect, and in accordance with the wishes of the adult where appropriate. As the inquiry progresses, there will be a need to establish the facts. And I've underlined that because, in my experience, that is the most challenging part of an inquiry for social work practitioners, and we're going to come on to look at what findings are in due course. Once we've established the facts, to prepare a final safeguarding care plan and then make decisions as to what follow-up action should be taken with regards to the adult or the organisation responsible for the abuse or neglect. So, should the police be involved? Should there be a prosecution? What does the adult that we're trying to protect and empower say about that? And finally, consider whether the adult, what needs to be done to allow the adult to achieve resolution and recovery as appropriate. So, responding to the referral, as I've indicated, and this is an extract from the Care and Support Statutory Guidance. As I've indicated, the first priority should always be to ensure the safety and well-being of the adult. Does something need to happen immediately? Is it safe for the adult, for example, to remain in their own home? Do they need to be moved to a residential setting? Could a court order be secured to keep them safe in their own home, injunctions perhaps against others? They're the sort of things that need to be looked at, and we'll look at them in more detail. But again, with the focus on capacity, the yellow part's really important on this slide. Practitioners should, wherever practicable, seek the consent of the adult before taking any action. Or undertake a best interest decision if they lack capacity, having established a lack of incapacity, and having considered the factors in Section 4 of the Mental Capacity Act when making a best interest decision, and including, in particular, ascertaining the wishes and feelings about from the adult. Carrying on with the statutory guide, whether or not the adult has capacity to give consent, action may need to be taken if others are at risk where nothing is done. So this is really important because the adult you're supporting may be of the view that they don't want any action taken, or they don't want the police involved, or they don't want the CQC involved. And there are circumstances which we'll come to look at in more detail where it isn't appropriate to just take no action. And that can override a capacitous adult's decision that they want no action taken. And it can override a best interest decision that it's not in somebody's best interest for any action to be taken. The most obvious example, looking at those two circumstances, first circumstance being that others will be put at risk if nothing is done. And the second being it's in the public interest to do something about it. The most obvious example of the first is a residential setting where perhaps a resident in a care home has been abused, perhaps sexually assaulted by another resident, and there's a risk that that alleged perpetrator might sexually assault other residents in the care home. In those circumstances, and having made inquiries, it's perfectly legitimate that the social work team may find it's still necessary to involve the police in those circumstances, and they may decide that's so important that that overrides the adult saying they don't want the police involved. It might not do. It's something that needs to be considered on the facts at the time. What do we mean by public interest? In my experience, it's going to be rare that we decide to override the capacitous decision of an adult not to involve the police or want other professionals involved or have any action taken because of the public interest. When we talk about the public interest, we're talking about the seriousness of the offence, the level of culpability of the perpetrator, how likely it is to happen again and to other people, the circumstances of the perpetrator, the impact on the community and things like that. And I can't think of an obvious example about where the public interest would lead us to ignore somebody's capacitous decision, that they didn't want any action taken. So we do have some judicial guidance about the approach to safeguarding for a local authority. There aren't many cases about safeguarding because generally these cases don't reach the court. But in the Re-Z case, which was a decision of Mr. Justice Headley as he was then, the judge set out 9 points for us to consider. And he said the local authority has the following duties. The first is to investigate the position of a vulnerable adult to consider what was her true position and intention. So we've seen that, that's established wishes and feelings. The second is to consider whether she has capacity to make and carry out her decision and intention. So a focus on whether or not it's a capacitous decision. Third, to consider if she has capacity, whether for some reason she's under some undue influence, which is preventing her from making the decision, or if she lacks capacity, whether some undue influence is operating such that she isn't able to get all of the relevant information and know all the options available to her. I missed out the fourth one, it's not relevant to the discussion. The fifth is to consider whether to apply to the Court of Protection. So the issue of the question of capacity could be judicially investigated and determined. So for example, you might find that the adult you're working with is unable to retain the information to make a decision. They don't understand the information and they can't use and weigh the information to make the decision. But there's no obvious diagnosis to satisfy the diagnostic test in the Mental Capacity Act. So whether or not there's a disturbance in the functioning of the mind or brain. And in those circumstances, it's legitimate to apply to the Court of Protection so that the court can make directions to gather evidence about whether there is a diagnosis and to decide whether, even absent a formal diagnosis, interim declarations should be made under Section 48 of the Mental Capacity Act, i.e. whether there's reasonable cause to believe that the person does lack capacity. Carrying on with the points on the slide, point 6, in the event of the adult lacking capacity, Mr. Justice Headley said that the local authority has to provide all such assistance as may be reasonably required, both to determine and give effect to her best interests. 7, if the adult has capacity, and this is really important, to allow her in any lawful way to give effect to her decision. Although that doesn't stop the social worker, His Lordship says, giving advice or assistance in accordance with what the social worker perceives to be in her best interests. The social worker can persuade and offer advice and encourage, but ultimately if the adult having capacity wants to make an unwise decision, they have to be allowed to do it. 8, if there are reasonable grounds to suspect the commission of a criminal offence, subject to what I'm going to go on to look at later, draw that to the attention of the police. And 9, in very exceptional circumstances, to apply under the inherent jurisdiction of the High Court that has wide powers to make declarations and orders in respect of people, even if they have capacity to make their own decisions. So when might we apply to the Court of Protection? Well, the Court of Protection has obviously wide powers, as you will all know, under sections 15 and 16 of the Mental Capacity Act 2005. Adult safeguarding is often an issue within a Court of Protection application. Very often, it's the involvement of adult safeguarding that really flags up the need for matters to progress to the Court of Protection. Maybe it's somebody self-neglecting at home and they're not allowing carers in, and the situation has become intolerable and the local authority has decided that it's in that person's best interest to move to residential care, but they won't go. In those circumstances, only by an order of the Court of Protection could force a reasonable force be deployed to move the adult to a residential setting. Only with an order of the Court of Protection could medication be prescribed to assist moving a vulnerable adult from their own home to a residential setting. The Care Act revoked the local authority's power to unilaterally remove an adult from their own home. Other examples which may lead to proceedings might be where an adult has presented with injuries and it's not clear who's inflicted those injuries upon the adult, but it's likely to be somebody in their household. In those circumstances, it's likely to be in the adult's best interests again to be removed from that setting, and unless there's agreement across the board and no objection from the adult, an order from the court's likely to be required there. It might be that the safeguarding inquiry has run its course and findings have been made that injuries were inflicted upon an adult by a family member, and the best interest decision is that they live elsewhere, and the family member who is said to have perpetrated the injuries disagrees, and he wants to challenge the best interest decision in the Court of Protection. Again, application to court protection in those circumstances. So we've got the examples on the slides there. We also have, of course, the inherent jurisdiction of the High Court, very exceptional circumstances, a jurisdiction to protect a vulnerable adult. And very briefly, a vulnerable adult defined by Lord Justice Mumby in the Re-SA case, somebody who is under constraint, subject to coercion or undue influence, or for some other reason deprived of the capacity to make the relevant decision or disabled from making a free choice. So that's they're the applications to courts. So we're about halfway through, and I want to move on to 5 issues that I have come across over the past couple of years, which I think are really tricky issues for practitioners, and I want to share my thoughts on those issues with the hope that they may help all of you in your own practice. So dealing first with refusal of assessments, and the legislation is section 11 of the Care Act. That says an adult can refuse a needs assessment, and if it does so, the local authority doesn't have the duties as set out in section 9 and 10 of the Care Act. But there are exceptions. The first exception is where an adult lacks capacity to refuse the carrying out of an assessment. So in order to be satisfied that somebody lacks capacity, there need to be some form of assessment. So there you have the circular issue. How do you undertake the mental capacity assessment about whether or not somebody has capacity to refuse to engage in a Care Act assessment if they won't engage in the assessment in the first place? It's tricky, but it's generally achievable over a period of time in my experience, because service users often, or people in this situation who don't want local authority involvement, interact for short snippets here and there. And when we think about what the relevant information would be that somebody needs to retain, understand and use and weigh to make the decision to refuse a Care Act assessment, it's not particularly onerous. They need to understand what the concerns were that had led to the referral to the local authority. So what the concerns are around their care and support needs. Very often, that's they've been admitted to hospital after a fall. So do they understand they've had difficulties with mobility that's led to hospitalisation? They might be concerns from neighbours that the service user is presenting with some care and support needs. Perhaps they're going out late in the community, late at night and becoming disorientated. Perhaps they aren't eating. All of this information needs to be shared about why there should be an assessment. Service user would need to understand the purpose of the assessment. So it's an assessment to establish whether they need any help with their care and support needs, with a view to providing that help. and they need to understand that if the assessment didn't take place, they wouldn't get that support. So for my part, it's as simple as that. They're the three key pieces of relevant information that an adult would need to understand in order to have capacity to refuse the assessment. And even if you're just getting your head in the door or you're speaking to them on the phone for 5 minutes here and there, over time you should be able to build that picture up about whether there is a retention and understanding of the information. And if you find that there are concerns, then that will be sufficient to found a lack of capacity at this stage. The other exception is, and it's bang on for safeguarding really, a local authority can't accept refusal of assessment from somebody in circumstances where they are at risk of or experiencing abuse or neglect. And of course, the local authority must be concerned about that if it's had a referral in through safeguarding. So what to do in those circumstances? Well, the local authority's duty is to carry on banging on the door and trying to support the adult to engage in the assessment. And if the circumstances are really serious and the service user is becoming seriously unwell through self-neglect or there is a real serious risk of abuse, then it's in those circumstances that the local authority may well need to apply to the Court of Protection for directions around how an assessment would take place. They're very tricky cases indeed. The Care Act statutory guidance is just set out there for your reference, which you can really, I think you'll get the slides afterwards, so you'll be able to have a look at that then. So that's what I've got to say about refusal of assessments. Once you've had the safeguarding referral in, the first thing to think about is whether there needs to be an interim safeguarding plan. This is a care plan in effect that needs to be put in place immediately to ensure somebody is kept safe until the safeguarding inquiry can gather all of the evidence it needs to be able to make final determinations. So I've given examples as we've gone through about an adult who presents with bruising and we don't know who's done it. It might be that it was somebody in the household. It might be that the adult is saying it was somebody in the household and doesn't want to go home. So in those circumstances, safeguarding practitioners need to think very carefully about whether something should be done, whether a residential placement should be found, or whether the adult can go and stay with other relatives for a short while. Whenever that issue arises, effectively removing someone from their home, the other thing that must always be considered is called the balance of harm. So is it harmful in itself to deploy that protective measure? Particularly somebody that has autism who can't cope with change very well, removing them from their own home, which they're familiar with, and where they are expecting to go and to be, to put them in an unfamiliar setting with an unfamiliar care team, can very often lead to extremely challenging behaviours on the part of the adults themselves, and can place them at risk of serious physical and emotional harm of itself. So that has to be weighed in the balance against what the risks are of the adult remaining at home. It's really tricky. And if there's any doubt about where best interests lie, it might be that there's an urgent application to the Court of Protection. But there doesn't need to be. That's a decision which social workers can take in somebody's best interests, unless the service user is objecting, and it will be a deprivation of their liberty to convey them to the residential placement or to the alternative family placement. When we look at the issue of interim safeguarding plans, quite a few of the 6 safeguarding principles are extremely relevant. Empowerment, so that's really important when we think about this through capacity terms, through the Mental Capacity Act. Because if somebody has capacity to make their own decisions, then their decisions should usually be respected. And if they're very clear that they are going home and they don't want to go to a residential placement, or they don't want to go and stay with families, then in all likelihood they're going home. If there are grave concerns of serious harm for that person, even though they have capacity, if there are concerns they will suffer serious harm or even die, then it's those circumstances where consideration would need to be given to an application under the inherent jurisdiction of the High Court, who could make orders that for a short while that service user does go to an alternative place to live, even though that might deprive them of a liberty, and even though they have capacity and don't want to go. But they are rare circumstances, and only when the harm feared is at the extreme end of the category and irreversible. Other principles are prevention, so it's better to take action before harm occurs, and then that's a key thing to think about when we're weighing in the balance the risk of removing someone from home against leaving them there. Proportionality, so when we're considering such drastic action, is it proportionate in all of the circumstances? And protecting the adult's autonomy, protection. Do they need an advocate, a Care Act advocate or an IMCA? And if they lack capacity and we're making these decisions on behalf of them, then you must apply the criteria in Section 4 of the Mental Capacity Act. You must consider all of the things set out there on the slides and in Section 4. If the person's going to have capacity at some time, the question, can it wait? At some time in the future, can it wait? Must consider the person's past and present wishes and feelings, the beliefs and values that will influence his decision, and other factors that he'd consider if he were able to do so. Must take into account the views of anyone the person asks you to consult, anyone caring for the person or interested in his welfare, any attorney or any deputy. So the interim safeguarding plan then needs to be written up very quickly. It should usually be done the same day, but if not, the very following day. And it should specify how the adult's particular care and support needs are going to be met. It should specify what needs to happen in the meantime until the full safeguarding inquiry concludes to keep the adult safe. It should deal with all the practicalities of who can have contact with him or who might pose a risk. It should set out the legal basis upon which decisions are made. It should record the wishes and feelings of the adults if they've been established. It's a very important document. Moving on then to look at the situation where a crime has been committed, where there's been some form of abuse. That's also a criminal offence. And the starting point is paragraph 1483 of the Care and Support Statutory Guidance, which uncontroversially says that everyone is entitled to the protection of the law and access to justice, and explains that behaviour which amounts to abuse and neglect will usually be a criminal offence under various pieces of legislation. It says that where criminal activity is suspected, then the early involvement of the police is likely to have benefits in many cases. The most obvious example is the preservation of evidence, or maintaining the forensic value of evidence, preventing it from being contaminated. However, before the police become involved, you need to seek the adult's consent to report the matter immediately to the police. And if the adult has mental capacity in relation to that decision and does not want a report to be made to the police, then that should usually be respected, unless, as we've looked at, the exceptions that I spoke of earlier apply to override that concern. So the adult's subject to coercion or undue influence to the extent that they can't consent, the overriding public interest, Or, and this is the third one that we didn't discuss earlier, but is very important, it's in the adult's vital interest to prevent serious harm or distress or in life-threatening situations. Obvious example there might be that you've spoken to the service user or the adult by telephone. They've said that they're worried that they're in danger, and you go to the house and you can't get in, and you need the police to come and exercise their powers in the Police and Criminal Evidence Act to break the door down and go in and see what's going off. If consent is overridden, there has to be clear, justifiable reasons for overriding the wishes of a person with mental capacity. That needs to be based on all of the circumstances, and it needs to be properly recorded and written down. If they lack capacity to make this decision, then decisions need to be made in somebody's best interests. I'm going to come on in a moment to look at what I think you need to think about in undertaking a capacity assessment in those circumstances. So where somebody has capacity, I'll just set out in this slide here that there has to be respect for that capacitist decision. And that's because Section 1 Mental Capacity Act, there's a presumption of capacity. And we know that unwise decisions don't mean that they don't have capacity to make the decision. And very often in these cases that are not uncommon at all, unwise decisions are being made. And the most obvious example I can share with you, and you'll all have come across these cases, are it's usually an elderly lady living by themselves, and they're supported by their children. Of course, it can be any other family situation, but I find that the most common. And their sons or daughters are stealing the money. They're taking the bank card, they're going down to the bank and they're taking the money. And you tell the adult this, and they say, "Oh, that's really sad, I'm upset about that, but I don't want the police involved. They're my sons or daughters, and I don't want the police going after them." And that's something that has to attract a great deal of weight, even in a best interest decision. But in considering whether the person has capacity, it's my view that that's quite a human thing to protect your own sons or daughters, and it's not uncommon, and it doesn't mean that somebody lacks capacity. In those circumstances, very often the capacity assessment can become conflated with best interests, and people are found to lack capacity because they don't understand that their son or daughter is stealing from them and that sort of thing. So there's the quote there from Mr. Justice Cobb in the Rees-Ed case, and another one here from Mr. Justice Baker, as he was then in the Oldham case, about capacity assessments taking into account overly paternalistic things and not being detached and objective. So what would somebody need to understand to have capacity to make a decision about whether or not the police should be involved? Well, in my view, it's this. And of course, it has to be tailored to the specific case. But generally, these are the things that I'd be looking for that you would discuss with the service user as part of the capacity assessment. First, they need to understand that they've been abused. They need to understand who did what to them when, if it's known. So on the example I've given, your son or daughter came round and they've got your bank card and they've gone and taken your money. If it's a case of somebody being physically harmed, the circumstances around that would need to be shared with the adult as part of the capacity assessment. So you were living at home with your son or daughter, and they lost the temper while they were caring with you, and they pushed you to the bed or restrained you with the arms or with your arms or legs, or otherwise restrained you. It needs to be shared with the person in order that the assessor, the social work practitioner, can see that they are retaining the information before going on to consider whether they can understand that information and use and weigh it. There needs to be an understanding or sharing about who the alleged perpetrator is and their relationship to the adults. They need to know that if the police became involved, it might cause difficulties in that relationship. They need to know that the abuse amounts to a criminal offence if it does. They need to know, if it's right, that there's a risk that it would happen again. If it's happened before, they need to know that. They need to know that if the police weren't called now, evidence might be lost, and the police might be less likely to be able to help in the future. And importantly, this final point, they need to know that the alleged perpetrator, who might be their son or daughter, might be prosecuted. They might go to prison. It looks like a lot, but it's not complicated relevant information, and it's something that a person should be expected to be able to retain, understand and use and weigh if they've got capacity to refuse for the police to become involved. After all, the Mental Capacity Act is seeking to empower people to make their own decisions, and even where they lack capacity, we've got the quote here from Mr. Justice Hayden, the Mental Capacity Act seeks to empower incapacitous people to make or participate in making decisions for themselves. So all of the information, all of the relevant information there, even if the service user can't use and weigh that to make an informed decision, that's all relevant information about their wishes and feelings that would inform a best interest decision if it is the social work team that are taking the best interest decision about whether or not the police should be involved. If you are taking a best interest decision, and I've tried to set out a few of the points that would point either way as to whether or not the police should be involved. I have to say that I would struggle to think of a case where it's been decided that it's not in somebody's best interests, or it's in somebody's best interest for the police not to be involved. But there must be a case out there where that is applicable. In any event, if your decision is the police should be involved, it needs to be properly reasoned with the pros and cons, and it needs to be properly recorded. Because, as we know, one of the principles of safeguarding adults is accountability and transparency. So the final point in the last 8 minutes that we've got on the presentation that I want to talk about are where a vulnerable adult claims to have been harmed and going on to make findings. And honestly, it's a topic I could talk about for more than an hour on its own, but it's such an important issue. We're going to do a whistle-top tour of it now, and if anybody's got any questions about these sort of cases in general terms, then I can respond to those by email. So, fundamental starting point that when a vulnerable adult or anyone tells you that they have been harmed or abused or hurt, at that stage, it's just an allegation. It is not a disclosure. And all of the time, people ring up and speak to me and my colleagues and say a disclosure's been made. For a long time, that was what was taught at university on professional courses. But we really need to be very careful to distinguish between an allegation, where somebody says something's happened, and a disclosure or a fact, which is something that's established. An allegation, as you will obviously know, may or may not be true. What is a fact? A couple of definitions for you there. I prefer the second definition, which is a fact is something known to be true, something that can be shown to be true, to exist, or to have happened. And when it's set out like that, its context in adult safeguarding is obvious, but we're going to go through it now anyway. So, few practice points about where a vulnerable adult claims to have been harmed. First, there has to be a clear and comprehensive record of what the adult said to who, by the person it was said to, as soon as possible after it's been said, and in the terms used by the adult. And if we can put that in quotation marks to show in the notes that it was the exact words the adult used, that will be very helpful. If it's a social worker that's having that discussion with the adult, then they need to be very guarded about avoiding leading questions and not encouraging too much information to be shared at that stage, which would undermine the forensic value of the evidence later. But on the other hand, the social worker needs to establish information to ensure that that adult can be kept safe right there in the immediate there and then. Needs to be from the very off thinking about whether there needs to be an achieving best evidence, an ABE interview with the police if involved, or led by social workers, or some other form of appropriate work with the adult to elicit what they want to tell us, and to achieve the very best possible evidence, because it's only by achieving the best possible evidence that you can, with any degree of certainty, safeguard that adult. When you're collating evidence in these circumstances where allegations of harm have been made, it's my advice that social workers should always speak to their legal services department. The most obvious piece of experience that legal services can often impart to safeguarding social workers is the instruction of experts. So before I worked in adult social care, I did a number of years working in children's social care, and injured children that have bruises or shaking injuries or fractured bones come up much more frequently than adults, because they're less able to protect themselves from adults and quickly come to the attention of services. And I have experience of being able to, as a layperson, say something doesn't quite look right, so perhaps the pattern of bruises is suspicious and it doesn't comply or it doesn't fall easily with, in layman's terms, the explanations put forward by the family. So if the vulnerable adult is covered from head to toe in bruises, and the account that's given is, we had to restrain him, and we did that by hugging him and pulling him to the ground, for example, does that explain all the bruises? And if there is any doubt, an expert clinician, somebody that specialises in the area of dealing with accidental injuries or bruises in a hospital setting, needs to be identified to provide that piece of information to the safeguarding team as they lead their inquiries, an opinion about the mechanism, how the injury was caused, or indeed, so the mechanism, what mechanism caused the injury, and causation is, has it happened in the way the person has said based on the injuries that are ascertained. Speak to legal services really quickly. Can we get, for example, cooperation, as we've spoken about, from health, to get medical photographs taken of the bruising at a really early stage and preserve that evidence? So that's what I've got to say about dealing with vulnerable adults who have been hurt or make allegations of harm. Finally, the safeguarding team, as part of their inquiry, has to make findings. They have to decide what has happened. They need to decide whether the allegation of abuse or neglect is substantiated. They make decisions on the balance of probabilities. Pausing there, the police, when they decide whether to investigate or prosecute, work to the standard of proof being beyond reasonable doubt. Has something certainly happened? Are they sure it's happened? So just because the police say there isn't enough evidence to prosecute does not stop the safeguarding inquiry from happening. And there's very good reasons why a local authority safeguarding team work to a lower standard of proof. And that is because sometimes adults are abused, and it might not be possible to found a prosecution and prove beyond reasonable doubt that something has happened. But if we can establish something to a lower standard on the balance of probabilities, more likely than not to have happened, 51%, in order to keep them safe from the harm happening again, then we have to do that. So if the police say there isn't enough evidence to prosecute and close their involvement, that is by no means closure of the social work team's inquiries. They must still continue. They must decide whether or not the evidence establishes the concerns on the balance of probabilities. Any findings of fact have to be based on all of the evidence. So if the police are involved, you want to see all the evidence the police have collated, their interviews with the perpetrator and the wider family. The police aren't doing that. The social work team needs to interview the family members themselves. They need to consider medical evidence. They need to speak to the GPs and other professionals involved. They need to speak to care providers. They need to review historical social care records. If they can, with consent, they need to consider the social care records of any suspect or alleged perpetrator. Can't make a finding that something might have happened. You can say you suspect it might have happened, but it's not reached the standard of proof, so you're not satisfied on the balance of probabilities. And if it doesn't satisfy the balance of probabilities, then when you come to do your care planning, your final care planning, then you treat it as not having happened. If it's not a finding made on the inquiry, then when you care plan, it didn't happen. And finally, you need to be aware that people might lie to you as part of your inquiries. They might become confused. They might lie to you because they have abused the adults. They might lie to you because they're embarrassed. They might lie to you, and we've got that final bullet point, a well-known quote from the Lucas case. They might lie for many reasons, out of shame, humiliation, misplaced loyalty, panic, fear, distress, and the like. So you have to make the findings. Once you've made the findings, you then have the factual basis to go on and make the final safeguarding plan. You now know what's happened, and you can decide the long-term plan to keep the adult safe and to promote their well-being. And if they've suffered really serious abuse at home, that might be that they can't go back home. It might be that some work needs to be undertaken with the people that live in the home before they can go back to help them show what's gone wrong here. Because the abuse might have happened because the carer, the family carer at home, was at the end of the tether. So you might have a carer's assessment, and you might put in support to prevent that from happening again. But you can't make that decision until you've made the findings. So that's the end of the presentation. I've tried my best to keep to time, but we are a little over. So are there any questions? I can't hear Alison, so I don't know if it's just me. I certainly can't hear anybody, so I don't know. Don't know if it's just you I can't hear, Alison, or whether everybody else can.
I can't hear her either, Brett. It should be. You should have the unmute in your bottom left of your screen, Alison. Yeah, I think we just heard you then, Alison.
Can you hear me now?
We can hear you now.
Brilliant. Okay, I'm so sorry about that. I think my microphone's failed. Right, the first question is from Rachel. Does self-harm and suicide come within safeguarding?
So self-harm obviously does, because that's a form of self-neglect. But if somebody's committed suicide, then it most certainly does not come within the parameters of Section 42 of the Care Act, because in those circumstances, it's an inquiry relating to somebody that's alive. Actually, after somebody has committed suicide, there's likely to be an inquest. The police will prepare evidence for the inquest, and the coroner will look into those circumstances. So there isn't a role for the local authority usually. There may be circumstances if somebody has committed suicide in a residential setting and there are concerns that the suicide was brought about by the carers there, that there are wider obligations on the local authority to consider. Perhaps it's the commissioning body of the placement, and it needs to investigate as part of the contract it has with those, not just for the late service user, but for other people that might be at risk. But more obviously, there'd need to be referrals to the Care Quality Commission, who have duties in those circumstances to investigate abuse and to make sure that the standards within the Care Standards Act and the regulations underpinning that have been met.
Thank you, Brett. And Maria says, can a carer/parent have the right to refuse a Care Act assessment on behalf of the person that they care for if there are no concerns and the referral came through as part of a transitioning process?
While they're a parent of an adult, possibly, and that would depend on the circumstances, because as a parent they have parental responsibility. But once they become an adult, and if the referral is for the appearance of care and support, then the obligation is on the social work team to speak with the adult and ascertain whether they are refusing the assessment themselves, and if they are and they're satisfied about capacity, they can leave it. If they think there are doubts about capacity, then they need to undertake the capacity assessment in the way that I described in the slides, and then take a best interest decision about the assessment can be refused.
Thank you. And Mia asks, please could we get access to copies of all the slides for the MCA seminars delivered today? I think we can do that. The next question is, I'm interested in the funding aspect. I understood that there was a move away from focusing on coming to a finding as part of the Section 42 inquiry to more focus on what the risks are believed or understood to be, and then the plan resulting from that. We no longer ask for a finding, for example, substantiated or unsubstantiated as part of our recordings.
I'm not particularly troubled by whether or not we record something as substantiated or unsubstantiated, but how can you have a risk without establishing what the factual basis for the risk is? So the Care Act statutory guidance is set and applies. It says local authorities must establish the facts, and only if you establish the factual basis can you then risk assess what the risks are from those facts. If, for example, you're in a situation where somebody has been abused at home, we'll take the example of somebody being physically harmed and they've got bruises, and the service user says, Mum did it, and Mum says, no, it was self-harm. Unless you get to the bottom of that, how can you then risk assess for that and keep the adults safe and ensure their well-being? In my view, you can't, so you've got to establish.
Thank you, Brett. Mary says, how do you approach the local authority who turns away from any safeguarding that's related to mental health? And she cites an authority who sends these to mental health services who often do not treat this as a safeguarding, for example, self-harm or self-neglect. Well,
mental health services should be integrated in most local authorities with the local authority. So whilst mental health services is principally the responsibility of a health trust, they should be integrated and there should be overlapping lines of responsibility and management. So that's the first part. It should therefore be within the remit of the local authority. But by judicial review if you need to, or a complaint, because the Section 42 inquiry will be triggered in the local authority, regardless of whether the support or the inquiries that need to be made sit in a different organisation. And it's for the local authority to require a response from mental health services as part of the ongoing inquiry. A local authority, if the criteria are satisfied, if the service user has care and support needs, if they are at risk of abuse and neglect and can't protect themselves because of those care and support needs, if those three criteria are satisfied, the local authority has got to get to the bottom of it, either by doing something themselves or requiring mental health to do it. And if they don't do it, make a complaint or get a solicitor and bring a judicial review. Or you could also flag it up with the Safeguarding Adult Board. The details of the adult safeguarding members should be on the authority's website, and you could write to them directly and say, this is a concern, particularly if it's a recurring concern and leads to there being some failure of policy or procedure in the authority. I hope it's not my authority.
It's not, Brett. I was just going to clarify that. Penny says, regarding reporting to the police, I work at MASH. We are expected at an early stage to report information to the police. For example, if we just get told of an assault with no dates, times, perpetrators, etc., were also expected to report incidents such as husband with dementia pushes wife who loses balance and falls. I feel uncomfortable about sharing such cases with limited information, especially as we can't always speak to the individual at that stage. Is it right to share information with the police at that point, or should it be done once further information has been achieved at the point of inquiry service being involved?
I understand there are a number of authorities, even in West Yorkshire, that have an integrated multi-agency safeguarding hub where the police are involved from the outset. I think I've said enough in the slides to express my very strong opinion that that isn't the way the law is supposed to operate. And we're here talking about the Mental Capacity Act. It's the sort of thing that takes that decision away from the service user about whether the police are involved, and it doesn't empower them to make their own decisions. It walks all over the principle of empowerment and personalisation that runs through safeguarding. And my view is that no, information shouldn't be shared with the police in those circumstances.
Thank you. And just one final question, Brett. I think I can sort of paraphrase it. I think the question is from Safiatu. I hope I pronounced that properly. What if, for instance, the adult is transferring money and this is affecting his ability to contribute towards his care or pay for food?
Well, that would be part of a capacity assessment, wouldn't it, if we were looking at the adult's capacity to make decisions about the finances, which might be one of the tasks the safeguarding inquiry throws up. But ultimately, it might be an unwise decision. Ultimately, it might lead to the local authority bringing court action to recover the charges. But it's something that an adult's entitled to do, entitled to transfer the money to anyone. If you can't point to undue influence or coercion, or it being a particular problem for the adult, you're going to struggle to do anything about it.
I think we're just 2 minutes, if you can be very quick, Brett. I'll just ask you this, it's just come in. I would agree that self-neglect is a Section 42 inquiry issue. I am not clear that self-harm is. Is it Brett's view that self-harm is a form of self-neglect? I think it's a bit of a grey area in the Care Act and statutory guidance.
Well, there has to be a duty to protect somebody, doesn't there? This is all about protecting a vulnerable adult. And if they are self-harming and they have care and support needs, I'm pretty sure it would fall within the definition. I think it's you're neglecting your own health in those circumstances. You might argue that it's not neglect and it's a deliberate act. There's sort of circumstances that don't arise in isolation either. I think if somebody is self-harming, then when you investigate further, there'll be other evidence that they need some help and support from the authority. It might be that the safeguarding duty isn't triggered in those circumstances. Off the top of my head, I haven't looked into the issue in great detail, but there's certainly going to be somebody that has an appearance of needs for the purpose of there being a needs assessment under Section 9 of the Care Act. It certainly sounds like somebody that's going to need support under Sections 18 of the of the Care Act, or somebody that needs support from the CMHT, it would be wrong of the local authority to just say it didn't come in with the safeguarding and to leave it and not deal with it. So I can say that.
Thank you, Brett. That's really helpful. Can I just say thank you, Brett, for your time this afternoon. It's been extremely interesting and informative. I'm sure everybody out there has enjoyed it too, even though you can't see them. It's not as easy doing this as having a live audience. So thank you very much for your time, and thank you for everybody that's joined us. Good afternoon to everybody. Thank you.